Okay, good afternoon and welcome to Global Lead Group's latest webinar, the Corporate Response to Fraud, Risk, Reputation and Recovery. So today's chair is Mateo Jarriv Cuvi, Global Associate Director at the Association of Governance, Risk and Compliance. And he's joined by our three speakers. Firstly, we've got Keith Oliver, Partner and Head of International at Peters and Peters, and the contributing editor to the CDR Essential Intelligence Fraud Asset Tracing and Recovery publication. We've also got Richard Strike, Director at Complyport, and finally Harry Jupp, Associate Director of Legal at Flutter Entertainment. In today's webinar, we're going to explore the UK's failure to prevent fraud offence, the best way to structure an internal investigation, managing reputational fallout, and lots of other really interesting things. So I'm already very much looking forward to this conversation. And so with that, I'll hand over to you, Matteo.
Thank you very much, Ella. Welcome everyone to this webinar. This is a webinar with GLG that we co-host alongside them. We do three or four of these per year. And very happy to be here with Keith, Harry, and Richard. We have 9 questions that we're going to try to cover here, looking at fraud, both from a legal and law enforcement perspective, as we have 2 lawyers with us, and we also have Richard, who is former law enforcement and consultant. So it should be an interesting discussion. I would like, each one, first of all, actually, before I get going, we will have some time, hopefully towards the end of the session, to cover some of your questions. So if you're listening in and you have any questions as you're, listening to what Keith, Harry, or Richard have to say, just use the Q&A function on Zoom, and I will be monitoring that, and I will either work the question into the discussion or I'll save some of those questions for the end of the session. Hopefully we'll have some time for those. I know we do have 9 questions that we're going to cover. So very quickly, I would like the 3 gentlemen to please introduce themselves. Just tell us a little bit about who you are and what is like your particular interest in fraud prevention, let's say. So Keith, please.
Well, good afternoon, everybody, and thank you so much, Matthew, for the introduction. Thank you for GLG for organising this. And although, ladies and gentlemen, I can't see any of you on my screen, I'm told there are over 100 of you listening or watching. And thank you very much for giving up an hour of your time today. I thought I'd just kick off. I'm Keith Oliver, Head of International at Peters and Peters. I've been here, it does date me, for well over 45 years, which does date me, but been practicing in this area and little else from the day that I started way back in 1980 when I qualified. So I've had some experiences which I'll be very happy to share with you. I just wanted also to say that we ought to have say a little prayer as we start, because today, ladies and gentlemen, is the 60th anniversary of the day that England won the World Cup. And having sadly experienced England live losing to Argentina 2 weeks ago, at least we can look back. And just to show how much things have changed, the cost of a ticket in those days was 7 shillings 6 pence, equivalent to 37.5 pence in today's world. So I just thought I'd share that with you as we start. Thank you very much.
Interesting fact. Thank you for that, Keith. Harry?
Hi there. Hi, everyone. Yes, unfortunately, I can't say that I was at a recent World Cup game, but I'm Associate Director of Legal at Flutter Entertainment, sort of covering litigation and investigations work in-house. Prior to being with Flutter, I was in London private practice for over a decade. That's me. Looking forward to this. Thank you.
Last but not least, Richard.
Yeah, thank you, and hello everybody. My name's Richard Strike. I'm here just to listen to the other 2 experts and maybe add a little bit extra. But I'm a former law enforcement officer. I was a detective for the West Yorkshire Police. Did 15 years in complex fraud investigations, and now have a consultant. I do training UK law enforcement and international on economic crime and asset recovery. So hopefully I can give a slightly different perspective from a lonely old detective who, So hopefully I can avoid getting on my soapbox, which is quite easily to do these days when it's talking about fraud. So, but thank you for having me.
Excellent. Thank you, Richard. So let's get started with our first question to sort of set the scene. And I want to start with, let's say, the law enforcement perspective here. So this one's for you, Richard, and then we'll hear from Keith and Harry too. But, what are you seeing right now as the biggest driver of corporate fraud risk in the UK and the EU, if you want to expand beyond the UK? Is it economic pressure, technology, such as AI-enabled fraud? Is regulatory change, or is it something completely different to any of those? Richard?
Yeah, thank you. I think from it's all of the above, really, from my point of view. I left sort of policing in 2019, and I now concentrate on training. And I hear a lot of the fraud investigations which are ongoing. But as part of my training, I always talk about the Cressy's triangle, this opportunity, pressure, and rationalisation, which is it's never been more prevalent, really, because we've all got the opportunity to commit fraud, and it's now the pressures that we're seeing. It's this overinflation, it's these higher operating costs, pressures of financial targets. So we're going to see that pressure element of that Cressy's triangle coming more into fruition, I think. And then when you're looking at occupational fraud, and it's that rationalisation, it's disgruntled employees who maybe aren't hitting their targets or getting sort of bad appraisals and things like that, and departing employees. Now we've had this sort of access to remote working, which when I was in law enforcement, it was only just becoming a thing. But coming into COVID, obviously now more and more companies are going to remote access working from home. They have access to databases and things like that. So I think there is going to be the pressures and the rationalisation for insider fraud and occupational fraud. AI is obviously it's always going to be about, and it's quite easy for me to say, oh, AI is going to be the main driver. But how I sort of see it being influential to more types of fraud, or putting that risk of corporate structures to fraud, is obviously deep fakes, and we've talked about that, and you've seen videos of those before. But phishing emails are going to be more sort of accurate now, whereas we love to sort of make joke of the poor grammar of these emails and things like that. Now with AI, we won't get that, so they look very, very much like a real email with less spelling mistakes, and then your success rate is going to be a lot higher, and your fake documents that can be created from AI and things like that. Organised crime group, sort of that's going to be a major part of it as well. I think that now, and this is where I won't get on my soapbox talking about the fraud sentencing guidelines, but I think now organised crime groups are seeing that it's beneficial having insider frauds or people placed within organisations, HR, call centres and software developers, because then they can utilise that experience as a way in, a gateway into that corporate structure. And if there's limited or not particularly good processes in place, it opens the door then at that point, and that's why this new legislation is so important, really. So I could talk about it a long time, but it's I'll hand over to my other experts to hopefully cast their views on it as well. But hopefully that gives a bit of an idea.
Excellent. Keith, what's your view on this?
Can I go slightly off on a tangent? Just want to come back and ask Richard something that he raised, because we're trying to, I hope everybody understands, we're trying to be conversational about this. Richard, do you think that in today's world, people are, having obviously been at the coalface as you have for so long, do you think now that people are less or more dishonest, or do you think that it's just shades of dishonesty that have always existed and have simply developed in the more technological world in which we now live?
Yeah, it's a great question. I think more dishonest. I think fraud's always been there, and the opportunity's always been there. Do we take those, and we just rely on that? So and when you look at the sort of different fraud types, these occasional fraudsters or opportunists, do they just start by nicking a bit out these sort of petty cash, and then it sustains that, oh yeah, and they got away with it, then nobody saw it? Does that happen all the time, and then it just gets increases and things like that? But as I say, with the Cressy's triangle, it's never been truer, because I think more pressures now, people are going to look at opportunity and think, well, actually I could get away with that. I've worked here for like 15 years and I missed my last opportunity for promotion and I got overlooked, and it's almost like going down with a blaze of glory and think, well, actually I'm going to commit that fraud. If I get away with it, I'm probably going to get asked to leave the company. Are they going to report it to the police? Probably not, because it's a reputational risk. So they almost get away with it. And this is a common theme that I'm seeing now, or the discussions I'm having with police about this. So I think people are waning towards the rationalisation, I would suggest, which is probably testing their honesty more, if that's a bit of a sit on the offence answer.
Yeah. I mean, just picking up some of those, unless Harry wants to go first. Matthew, you're happy if I give you a couple of thoughts?
Yeah.
I mean, I thought I'd just share with everybody, of course, Carlo Ponzi gave obviously the name to the crime, Ponzi scheme, way back in the 1920s and 30s. He said when he was sentenced that when he addressed the court, that actually, yes, he accepted that it had been a pyramid scheme and that it developed the way that it did, but people had so much fun doing it that it was hardly surprising, and he almost wanted to be complimented for the entertainment value that he provided for all of his terrible victims. I mean, I think I was taught, my mentor many moons ago here, that told me this wonderful mantra, and I don't want it to be thought this is a Peters and Peters business plan, but as an interesting mantra of how this develops. It's this: the more regulations there are, and you can think about this, the more regulations there are more regulations for people to break.
Right.
So we live in a very ever more regulated world. And I remember way back in, it's very sort of anecdotal, but in the 1990s, before you had, so this is almost 30 years ago now, before you had the sort of instant communication that we all live with on a daily or hourly, minute by minute basis nowadays, KPMG launched in a big Stationers' Hall presentation, early 1990s, something called the KPMG Fraud Barometer, which was a clever marketing attempt, actually, and they simply added up the volume of all the frauds that were at that stage reported to demonstrate just how serious it was. And I think that if you look back in time, every decade has brought a different scandal. It's whenever there's a major scandal, then there's normally a government investigation or a regulatory investigation, and then either the Daily Mail or the Daily Telegraph will say, well, the law has to be changed, we're not being tough enough on criminals. But at the end of the day, and Richard may comment on this, there's never been enough resources. Although the Serious Fraud Office was introduced after the Roskill Commission, following the what was known as the Norton Rose scandal of the 1980s, that came in. There was a big Royal Commission in relation to fraud. The Serious Fraud Office came in, but however you judge its success, it's never had, in the way that possibly it needs to, sufficient resources for the purpose of dealing with it. And if you go from the introduction of the 1980s, you had Big Bang Financial Services Act 86, major prosecutions, Maxwell, Blue Arrow, Barlow Clowes, through the 90s. You had their stock market fraud, essentially, and grand larceny, alleged theft. But then things changed, and we moved into each decade bringing a new area of issues. Post 9/11, the buzzword, or I don't want to use an inappropriate language, but post 9/11, everybody was obsessed with anti-money laundering. And you saw how that impacted across not simply the financial services arena, but almost every part of our daily lives. I mean, how many of the audience in our daily lives want to do anything nowadays? It's very hard to do so without producing utility bills and identification from different sources for the purpose of demonstrating you are who you say you are. That then that decade sort of passed, and we then moved from sort of 2009/10 into anti-corruption, the introduction of the Bribery Act, internationally the great use of the FCPA, which was a piece of legislation that had really sat on the statute book in the US and had not been widely used, and then became the sexy thing that was used by, if I can use that word, not inappropriately, I hope, by the DOJ for many years. We had our Bribery Act. And then all of the consequences. Fraud lawyers tend to be busier in recessionary times than they do in times when you have a bull market. If you look at Warren Buffett's famous saying, it's only when the tide goes out that you can see who's been swimming naked. But the central theme, you have variations on a theme. There's always been fraud. There will always be dishonest people. And I think at the coalface, and we act for very substantially nowadays, losing claimant victims, corporates and individuals, but we have and still do act for, I hate the word defendant. I normally say the word misunderstood people. Some people have different shades of misunderstandings. But at the end of the day, criminals are clever. And although you can have law enforcement across the world having very advanced technology, the criminal fraternity and people who are flagrantly dishonest will use that. And AI has given them, and will continue to do so, huge opportunities. And it's affecting, it's very interesting if you look at the last, I was saying this to somebody at an event the other day, it's probably, we hear more about AI in the last 6 months than we have in the 6 or 60 years that preceded that particular period. because it affects
Right.
all of us.
Yep.
And I know there's many practicing lawyers are in this audience, and many of us, and we see it almost on a daily basis, have unsolicited potential instructions that are proposed to us, where the intended client says, or would be a wished for client says, well, here's the case. You don't need to do anything. Just I've done the research myself. Here's the case. Can you just go ahead and issue the proceedings? And of course you can't. But it shows just how quickly the technology can be abused and how effectively it can for people's pecuniary gain and advantage. Anyway, sorry, Harry.
Right. Harry, anything to add?
No, thanks. I mean, I'm still trying to persuade Keith that AIs can do the job 100%, and he's very resistant. But no, my comments are, really very similar, very echoing those points. Yes, of course, I think AI means that people potentially have better tools to do what they may want to carry out. AI potentially, in theory, we're told, right, is only going to get smarter and better, and therefore, the execution potentially with AI is just going to get better, make it harder. Yeah, I mean, another question just about people. We talk about honesty, and Richard touched upon this. You see it. There is that remote working, that outsourcing. There is potentially that disconnection, the greater disconnect between the individuals and the companies and the values, and the good people in the company may be able to spot these things or other behaviors, etc. And of course, like we probably always will touch upon resources. Like I think resources and maybe some of these, there are always particularly noteworthy big cases, instances, and all the rest of it, but they're probably few and far between in terms of the actual number that's going on, and you just don't have resources to cover them all. And that's that can be certainly a law enforcement problem, and potentially even a company problem, which then goes to the point, which is, yes, Keith made it, we're getting ever more regulated, everything's more and more complex, and for a company or an individual maybe considering this or going down this path one way or the other, they may get away with it because the expense that would have caught it isn't something that will be in this market or future that will be covered by the company, etc., and likewise doesn't want to potentially take any further action, real meaningful kind of deterrence on it from a reputational perspective.
Thank you, Harry. Now, staying on the topic of regulation, there's the new UK failure to prevent fraud offence, and now it's now in force. Let's take a little look at that. Sort of what practical difference is it making to how boards and general counsels approach fraud risk assessments and reasonable procedures? And also, are EU-based businesses with a UK footprint taking this offense or taking this regulation seriously enough? Keith, do you want to get us started with that one?
Well, I mean, look, Harry could probably speak to it because he's at the coalface in the corporate world dealing with this. If you look at the background to this, you had the Pivotal Fraud Act of 2006. Now that followed on. You had Proceeds of Crime Act before that in 2002, which was the anti-money laundering. Then money laundering regulations of 2017. Computer Misuse Act, Data Protection Act 2018, and GDPR, which we've all had to become used to dealing with. And the Bribery Act obviously imposed. I mean, initially when the Bribery Act came in, many of the lawyers who held themselves out as specialists in either investigating, prosecuting, or defending allegations of fraud sat around without very much to do other than training people to deal with the steps you had to take to ensure that you would identify internally and have control systems in place that would immediately expose wrongdoing and be able to bring the individuals responsible to book. I wanted to draw a slight analogy, perhaps, in relation to the Economic Crime and Transparency Act that introduced the failure to prevent offences with this, so it's slightly tangential. We, several years back now, were very much involved in representing companies that were caught up under the Enterprise Act in alleged anti-cartel behaviour. And many of the audience will know that the Enterprise Act criminalised cartel behaviour, bringing us very much into parallel with the the US in that respect that had a huge antitrust legislation there since the 1930s. But for the first 2 or 3 years, nothing very much happened. And I remember talking to another leading lawyer in this area with whom we did some joint marketing and or business development, and saying, well, is anything ever going to happen in this? And it comes back to a point I made just a few moments ago about resourcing. So yes, everybody's very excited about the failure to prevent. And for those of you that aren't immediately familiar with it, and the references for those that need it, Section 199 of the 2023 Act relating to major companies, large organizations. So that's currently, and it may obviously be refined and amended down the line, but you have an obligation to, you commit an offence if you fail to prevent fraud, with exceptions. I'll come on to that in a second. A large organisation described as one with more than 250 employees, 36 million turnover, or more than 18 million euros total assets. And of course, taking your point, Mateo, it does affect any company that operates in the UK. But resource-wise, are companies going to be prosecuted for it? And it goes back to my earlier point that you'll only see prosecutions when things go wrong. Mm-hmm. You know, you have to wait for when the next scandal takes place, and then questions will be asked. But the one issue area which I think has not really been analysed is that, yes, the corporate will be liable, and individual senior directors may well similarly be held to be criminally liable if they took reasonable steps to avoid the act complained of actually having taken place. But it may give rise, and this is one of the unforeseen factors early on, into a huge number of shareholder actions, because stakeholders or shareholders who've lost money as a consequence of a fraud may have civil claims they could possibly bring against the company for the purpose of having caused them financial loss, if and to the extent that there's been a reduction in shareholder value. And you've got very difficult Supreme Court authority in that particular area as the extent to which you can make claims. So I think it's probably a bit early to say. If you ran this, webinar, we did it in person in 2 or 3 years' time, in the same way that the Enterprise Act took a while to bed in, then you'll see. There is one thing I did want to flag up that we have picked up, though we weren't ourselves involved in it. Last year, in August 2025, HM Revenue and Customs prosecuted a firm of accountants based in Stockport. Please understand, I'm not being Stockportist for the purposes of this. I know that the whole of the government's moving to the north of England, courtesy of our new Prime Minister, but there's no particular reference to this. But they prosecuted a Stockport-based accountancy firm for failing to prevent, and these words, under new legislation, which is parallel to the economic crime provisions, failure to prevent the facilitation of tax evasion, which is very interesting. So I think, again, to the practicing lawyers here, leave aside the corporates and the obligations, the enhanced obligations to which Harry and his team, sort of thing that Richard is training people about, will have to deal with on a day-to-day basis. Harry's and other major, very senior GCs having absolute responsibility to ensure that their organizations are compliant every which way. You may well see, again, subject to my resourcing point, attack upon professionals for failing in their professional lives, having failed to take appropriate steps to prevent clients. And as you know, in the anti-money laundering area, you have very serious obligations to report with all of that's a different area, but all of the consequences that flow from that. The one thing is the final point, Matthew, on this, I'd say, and Harry can probably speak to this, it's extraordinary. When I started practice all those many moons ago in a galaxy, a long time ago, far, far away, there was not the same number of GCs employed in industry in the way that there is nowadays. And if you look at major companies like international companies like Flutter operating across the world, the size of their internal legal function is huge, because in order to ensure compliance, the companies and the directors and officers who run the companies look to their legal teams for the purpose of ensuring. And there's the absolute acute responsibility head on, ensuring that they are every which way compliant with the ever more labyrinthine world of regulation, accountability, and challenges that people have to deal with on a day-to-day basis. Sorry, Harry, I'm not trying to steal your thunder, but that's the way I see it from a private practice point of view.
Harry?
Yeah, no, thanks, Keith. Thanks, Mateo. Yeah, no, you're right, Keith. And you know, I'm always very pleased when you know, we like to change governments, change prime ministers, new agendas, and let's write new laws and rechange laws. And you know, we don't have a period where it just seems to settle. It's been a slightly crazy world, not just in that respect. So yeah, no, I mean, look, from our perspective, I mean, you know, this something that we'd have controls and processes in place, something we're fully aware of. You'd want to anyway from an internal perspective. But you know, this is a good opportunity to bring it back up. Certainly, grab some attention with the liability from the individuals, the sort of senior leadership, and review and enhance where necessary. And you know, potentially UC from guidance or case studies, other opportunities there. So you know, there are lots of ways to benefit and improve your internal processes and controls from this, and what comes out of it, and what may come out of it. But yeah, I mean, in answer to your question, I think there is a bit of an EU blind spot, and I think that's completely understandable for any sort of lots of companies thinking about they're only necessarily sometimes only thinking about their immediate environment, even though they may be operating in other territories or may have sort of risks to other jurisdictions. And so, yeah, that's a tricky element for any. I mean, perhaps when you're in a large organization and you've got these perhaps internal people with these understanding, these wider international understanding, or you've got offices and people around the world, it's easier. But and it's about, and it's something we may come on to, it's about kind of, you know, perhaps marrying the national with the global elements that you've got to sort of try and manage. And yes, the other thing perhaps is also looking internally, obviously at your own processes, but also within your whole sort of environment effectively, and whether that's classic example suppliers, right? And what you may be doing in terms of your processes, controls, contracts with suppliers, in order to, you know, protect the company from potential issues.
Thanks, Harry. Richard, any comments from the law enforcement side of things?
Yeah, just to echo that, really, when sort of Keith was mentioning about sort of anti-money laundering and the legislation coming in 2002, and then onwards for the money laundering regulations. If you look at that as a different concept, that's basically a failure to prevent money laundering, isn't it? And we've had it for many, many years now, and we're still failing at that, unfortunately, because you only have to look at Google search it and you'll see financial institutions, entities which are getting sanctioned and fined for failing to prevent this legislation, which we've had for years. So we've got to look at it realistically. It's going to be difficult. I think when I've spoken to Keith and Harry previously and we were talking about it, it's that I think big institutions have already had these anti-fraud policies in place, but now it's a legal obligation. So if they don't have it, then they're going to suffer the consequences of it. And I think that's going to be the learning. It's that first entity, that first legal entity that is going to get a sanction or criminal prosecution for failing to prevent it, and then everybody's going to learn from that, because they might look at it secretly and think, crikey, we do that, and then let's change action. But I think from a reviewer's point of view, when I used to sort of look at anti-money laundering processes, it would be what training has the workforce had on anti-money laundering, and each year there'd have to be some sort of certification or some sort of evidence, written evidence, that they've sat through some form of money laundering to keep them up to date with things. And if they didn't have that in place, then the liability is going to be on the money laundering reporting officer or compliance officer. So I can see that there's going to be a significant change with the board, because they're going to have to make sure that everybody's trained from the top down, and there's going to have to be evidence of such. Because if I'm going in looking at a company, and let's say, sorry to pick on you, Matteo, that I've got 1,000 employee workforce, and suddenly Matteo is the one who's allowed some fraud to happen, straight away I'm going to say, what training has Matteo had? And if it was 2 or 3 years ago, then Matteo can come forward and say, well, if I'd known what fraud was, I maybe would have prevented that. And then the finger's going to be pointed at the corporate bodies at the top, or the board. So there's going to be a big push on training and keeping everybody up to date, which, pardon my language, but is an arse covering exercise. So I think there's going to be a lot of that as well.
Well, Richard, that's very interesting hearing that slightly cynical perspective. But you're absolutely right in this context. All of us, we all know in our daily lives, we live in a much more governance-based world. Every law firm now has to have, and I'm not choosing this specifically as an example, but all of us have to have diversity training for obvious reasons. Now, how many of us in our day-to-day lives have training that is online, or where you're required to sit for 15 or 20 minutes in front, no disrespect to anybody who works online or remotely or whatever else, it's not a personal commentary on that, but you're expected, the tick box requirement to have undertaken training can so often be satisfied by having sat in front of a video presentation, tick the boxes, answered the relatively straightforward, mainly common sense questions that then put to you, and then it's filed away that you've completed the training. And respectfully, I think it's just nonsense. I mean, I think the only way to actually be trained to deal with some of these problems is collaboratively, to the extent that corporations can, around a table, working together. When I referred earlier to the Enterprise Act, so this is 20 years ago now, the criminalisation of cartel behaviour, together with one household name, the Magic Circle firm, and some other specialist firms like ours, we set up, addressed 200 corporates, live demonstrations in a conference room in a hotel, where we stage managed dawn raids by the Office of Fair Trading in a boardroom setting, where you walked in and said to all of the people sitting around the boardroom table, and we'll come on and deal with this in the connection to failure abroad, right? Everybody put their pens and paper down, give us your mobile phones, we're going to go through them. That was real training. That wasn't sitting in front of a machine and just being told what the law was. Mm-hmm. So I think it's extremely difficult to actually train people until you physically deal with it at the coalface and deal with the problem where you have to confront it.
Mm-hmm. Yeah, I'm sorry I fully agree, and it is difficult, and it's easy for me to say. And I've been, you get these online, and it's how quickly you can click the buttons to get through a 15-minute video in one minute. But I think that never becomes a problem. But I've always thought to myself that if I was ever looking at a fraud investigation or money laundering investigation involving that employee, that the time it takes to go through that questionnaire, that would be brought up in my eyes. Because if I'm going to court and I'm saying that individual has allowed this fraud or money laundering to happen, and when you look at their training, they've managed to complete a video in 1 minute, which when you look at the average, it's 15 minutes. I would suggest that the jury or the judge might be thinking, hang on a sec, you've clicked that and you haven't paid any attention to it. So it's probably never happened, but that's where I think the strength of that, are they sort of skilled or not, or that's because the employee is always going to point the finger at the board, and the board are going to point the finger at the employee if it has been used as a vessel for money laundering or fraud.
Right. Do you know, I'm sort of we're sort of halfway through. I've got just most people have their phones next to them. I've just had a text. Just read this. It literally arrived at just a couple of moments ago. It's from a bank, a well-known bank with whom I bank, and it says, Capital's warning: fraudsters have been calling customers, directing them to a fake version of our website. Please take care with unexpected calls. And of course, the question that I'm asking myself is, well, is that a fake message in itself? So it shows that we're living with this on an hourly basis. Sorry to interrupt, but just thought
is there a link on that message?
Happily not.
Okay, so might be real.
Indeed.
Excellent. Moving on now. Let's look at more practical aspects now. Let's look at the first 48 hours when, a company first suspects fraud. What are some of the critical early decisions, whether it's securing evidence, deciding whether to self-report, engaging forensic investigators, and where do companies most often get this wrong? And Harry, you can get us started with that one.
Yeah, thanks, Mateo. So in my experience, and it comes a little bit back to what Keith and we were talking about previously, sometimes something is discovered or thought it's discovered, and you can have lots of hairs running and people running, like, it's quite interesting. If a fire's going off, people running towards the fire, And the tricky thing sometimes is coordinated, or can be one of the trickiest things, is coordinating things and making sure that there is a bit of discipline, hopefully, and we aren't making moves that we may later regret because there's been no sort of control over them. So I think, it's about coming back to your processes, and part of that is your training, right? So that you have your training for these incidents and how you respond to them. Experience and actually having gone through these is great. Doing those kind of like online training forms, I feel like once you've done them, you've forgotten about them about 5 minutes later. And so the actual real world experience, real world training, to the extent you can, and the more you can do it, and the more you repeat those, and you have hopefully understanding from a wide group of people, and certainly the more senior the individuals, the better, of the process, the structure, and how you're going to manage it, then I think you're going to be in a better place. And one of the key things will be, it's the usual stuff, right? It's like, hold on a second, what are we reacting? Who are we involving? What are we doing evidence-wise, IT-wise? Who are we lockdowning with? Who are we getting in from a forensic point of view? Who are we getting in from a legal point of view? And who are we instructing, perhaps from a legal point of view, for privilege purposes as well? So things like that. And obviously, of course, part of those, you have various, you may have various teams, various departments, etc., involved, various considerations, including, of course, reporting and how you're going to report and who you're going to report to. And that also has to have a process in it as well, escalating a recommendation, a review, and obviously an execution on the reporting. And that's all in line with the timelines that you need to comply with as well. So that's kind of my experience of them, and how try and keep some element of control, and not also keeping it fairly limited to a number of people. So there may be lots of people involved, but you have a hopefully a fairly streamlined pyramid process.
Right.
So there is some sort of key decision making taken at the senior levels on the incident response team.
From a law enforcement perspective, Richard, what would you think the first 48 hours calls a company to do?
Yeah, obviously, from my point of view, it's all about getting that evidence for that particular investigation. But now, coming out of law enforcement since 2019, looking at it from a different perspective, I can see how reputational risk is a big issue, because you don't want to sort of raise the balloon straight away and then just have once it's up and everyone's aware of it. It obviously depends on different fraud type. I've been involved in ransomware investigations where companies have been breached, they haven't done anything about it, they're given them a timeline, and then they started advertising certain contracts online, open web, and these companies were then contacting the company to say, look, what's going on here? And then it was just a backlash of that, saying, why didn't you protect me, and things like that. So it's so difficult when you do come across these sort of incidences. What's the best thing to do in that 48 hours? Do you self-report like the ICO? If you do have sort of personal data, there is an expectation to report, but it's like soon as practicable, whenever that would be. And now the SFO, I've got no doubt, will be sort of looking at that self-reporting if there is a clear breach. And it's just, I think, we look at it from a negative point of view from a private sector company, but what they're actually going to do is assist and mitigate as much of that problem as they possibly can. But it's always seen as negative, because obviously you're raising the balloon straight away, and it could be sort of detrimental to business. I can see that.
In my experience, it's a classic, right? It's no surprise to anyone. You're aware, you've got some awareness, or you think you've got some awareness of what the incident might be, but it's still very early days. Time, and a lot of time and effort needs to happen before you can uncover more. So you're really in sort of a tricky spot in terms of you really don't know very much, probably straight away the first 48 hours, I would say, right? You're still very much in a information gathering exercise. But my experience is that actually, reporting that to regulators or other authorities, law enforcement, they're normally, I would say, pretty understanding about that, and they're not expecting, and nor would you expect, to be trying to go beyond, what you know, and even even saying very much at all, other than perhaps as little as the basic information that you've got as a sort of, we're flagging this, we'll keep you updated sort of thing. That's in very vague terms, but
sorry, go on.
Go ahead, Rich.
Yeah, I think just to add, I think decision making and is absolutely critical because it will change at every given minute. So I think when you're making a decision of what to do, justification of why you've made that decision is so clear. Because when you look at it a week later and think, why did I make that decision? When you've got all the information available, it's so difficult to be able to then to explain to somebody. So when that sort of emergency is kicking in and what do we do, there's going to be different elements. Suddenly you can have investigation or very quick one, new information. So decision making and evidential trails of those decision making. Why did you make that decision and what information did you have at that time to make that decision? Because sometimes hindsight, you look at it and think, oh, what a terrible decision that was. But you can't be criticized for that if you didn't have all the information made at that time. So documenting the decision making is critical, I think, in that 48 hours.
And that needs to be part of your process, right? It's in the decision making and the recording of the decision making.
Right. I think a good follow-up question here is, let's look at reputation management. You mentioned reputation risk, and I think Keith can sort of tackle this one for us. Fraud incidents rarely stay private for long. And, how do you advise clients on managing reputational fallout with regulators, customers, and the market, while, let's say, this investigation is still taking place and maybe facts are incomplete?
Well, just picking up both Richard and Harry said, the first, I suppose, dealing with a crisis. In Pulp Fiction, when Harvey Keitel rings the doorbell, and Quentin Tarantino, in a cameo role, the director of Pulp Fiction, answers the door, and Harry Winston Wolfe. Harvey Keitel says, "My name is Wolf. I solve problems. May I come in?" The most important thing is Harry's point and Richard's key decision maker, somebody who can accept, who will take responsibility, who will guide. You may have a committee. You've got to ensure, particularly when dealing with an internal problem, it can be an external problem, that somebody will take charge and give instructions, and to ensure that you lock down immediately all of the available evidence, and this is your reputational point, put an absolute lid from the very beginning on who is going to say anything publicly. Yes, if you've got a regulatory issue, you need to report. You tell the regulator, as Harry said, we've discovered an issue, we've retained X, Y, or Z law firm well known in this area. They are investigating it, or one of the major firms of forensic specialists, many of them out there, all very able. We're investigating it, we will report to you. But the leakage of that information, the fact of a problem, leave aside regulatory obligations to tell a stock market or a regulated environment where the shares are traded, which is a problem all of its own. The fact of the messaging is absolutely fundamental. Now, there are specialist reputational people out there. Many of your audience will know them all, household names in every respect, all very able. But the thing that's critical, this sounds like self-advertisement, which I assure you, everybody, it's not. It has to be lawyer-led, because you have to retain the privilege. But the issue, we'll come on to that, of waiving privilege is a very complicated one down the line. Regulators will ordinarily expect, if a company has conducted an internal investigation, that the work product will, privileged as between the client company and the lawyers, will have to be waived as to privilege for the purpose of ensuring, particularly when dealing with failure to prevent, coming back to our earlier exchange, that the company has done everything properly. But if you mismanage the information, I mean, I'll tell you a little story, if I may. I won't identify the journalist involved, but somebody I know very well who is at the FT. And as the audience will know, and individuals here may have had professional experience of this, the huge German scandal of some years back involving Wirecard, which was household name terms. Well, I was chairing a conference in Geneva, and I've got a close friend at the FT who was able to tell the audience how, I don't know if I should identify with male or female, but the individual was able to explain how that individual would, being Irish, with wonderful Irish charm, would just phone the company and say, "Oh, I'm so and so from the FT. I've just got some questions for you. Perhaps you could help me." And of course, because people who are not used to having their antennae sufficiently well sharpened to know where the danger signals are coming from. That individual, my friend, was able to obtain a huge amount of information by somebody who's only too happy to really open themselves to all sorts of quite dangerous questions that were posed in all innocence with this lovely, charming perspective. And you have to ensure, I mean, it sounds straightforward, but it's not. You have to ensure that people sitting at reception, if a journalist phones, will not answer a question. And you control the information that comes out. And this is the other key part. I think Harry and Richard will agree with me, and probably Mateo, you as well, and the audience. You have to have your key message. And you stick with that key message throughout. Yes, you're investigating. It will develop. It will evolve. It's organic. It's no black and white answer. You're receiving information all the time. But if you lose control, isn't it extraordinary that I was listening to the radio, LBC, the other day, that the Daily Telegraph appears to have the ability to obtain all sorts of information out of the Cabinet Office, because they seem to be ahead of the rest of the press in dealing. You saw the care home speech that Andy Burnham gave, I think, yesterday. Well, the Telegraph was able, well before anybody at 7 o'clock this morning, to identify exactly what the plans were that had been discussed. Now, that information should have been locked down. So there'll always be leakages, but you have to ensure that you're in control, and the people running the investigation reporting, let's say, I'm not suggesting anything would have happened, could happen, or would happen with Flutter, but would be able to report to Harry as the decision maker for the purpose of saying what was going to happen. And that's critical.
I think here I have a good follow-up question for Harry. I mean, just along the same lines, and this is the general counsel's, let's say, dilemma. You know, as an in-house counsel, I mean, how do you balance the instinct to protect the company and its leadership with the need to demonstrate like genuine cooperation with regulators, law enforcement, and what does the board actually want to hear from you in that moment, Harry?
Yeah, so I mean, in my experience, I mean, the senior leadership obviously want the best for the company, and quite often, I would say almost always, the best for the company will be cooperating with regulators or law enforcement. It may sound slightly odd to some people, but I don't think that it is at all. More often than not, and every time in my experience that has been the case. The best outcome for the company has been gained through cooperation with regulators and law enforcement. Some regulators and law enforcement, everyone's different. Depends on the people you get, etc. Some are much more understanding and welcoming of cooperation. Others are very skeptical, and it can be quite difficult to sort of get the cooperation back the other way that you'd expect, right? It's something of a two-way street, but also something that hopefully they would welcome, and we're often looking to cooperate absolutely at the full time. I mean, the board is looking for the things that the board always probably want, right? They want sort of clear practical pictures of the issue and the resolution and how we're going to get there. And if there is any issues in terms of conflict or individuals, then absolutely they should be getting their own kind of legal advice. So that's another key aspect, obviously, in any of these sorts of things where there are potentially other individuals, company individuals involved in the matter, that they do have that support from an individual perspective.
Yeah, and Harry, you'll have seen, and may have this internally in your own organisation. Many corporates have a zero tolerance policy, and the zero tolerance policy in relation to fraud is critical. It's critical in terms of setting the gold standard, but the essential part of it is the execution, because you have to make sure that as and when, because it inevitably does, dealing with dishonest individuals or suppliers or third parties who have taken advantage of the corporate, you have to actually implement it, because having a zero tolerance policy but then not implementing in when there is a problem
it's not a zero tolerance policy.
Indeed,
it's not, but yes, absolutely.
Yeah.
It's meaningless, isn't it? If you have a zero tolerance policy, but you never enforce it, then you're signaling that it's kind of open season, right?
Yeah, I was involved in a case some years ago. I won't obviously identify the corporate involved, and they were the victim of quite a serious fraud upon them. And one of the things we did in terms of obligations with third parties is to have a look at their contractual rights to carry out an immediate, unannounced audit of their suppliers, joint venture, suppliers' internal records. And we advised in that instance, we would simply turn up at the supplier with a forensic team and say, well, this is who we are, here's our credentials. We require the immediate right. No court order in that respect. We require to do so. There was a background to freezing order separately, but giving us the contractual rights. And of course, they could have refused, but it was instrumental in actually recovering the proceeds. So you have to think on your feet, but the control aspect of it is essential.
Thank you. Thank you for that, Keith. Thanks, Harry. We have about 10 minutes left, so I have a question from the audience I'm going to throw out there for the three of you, and then we'll have one question to wrap up. This one's about the whistleblower reward schemes, and the question is, can panelists discuss what they think the impact will be on economic crime enforcement and deterrence on HMRC's newly launched and strengthened US-style whistleblower reward scheme? And then there's Casey Jonathan Fisher's recommendation in part 2 of his review for UK government that the SFO should adopt a whistleblower reward scheme. What are your general thoughts on whistleblower reward schemes styled after the US? I don't know if Richard, you want to start there, and then we can hand things over to Harry and Keith.
Yeah, so I've got a limited involvement really, but I've done a bit of work in America, and this got introduced me as a very positive thing, as in, but I can see the negatives as well. From are you going to promote this sort of finger pointing with no real evidence against something like that? We do have something similar to this deferred prosecution agreement, which SFO have, but I think the rewards potentially to whistleblowers are limited, whereas I think the American institution, I think they get like 30% of the sanctions, and some of the sanctions are eye-watering, hundreds of millions, so the whistleblower can walk away, change their career and that thing. But are they doing it for the right or wrong reasons? I do like it because it now I like the idea of it because it promotes people actively or being sort of proactive in looking at malpractice within an organization. And if you have that, it's good because you're going to weed it out. But then it obviously, to counteract that, you're going to get this distrust, this paranoia, and things like that amongst the staff, and you're trying to create a team atmosphere. I can imagine that having an opposite effect to it. So I see the pros and cons. I don't think people should be doing it just to make money, which I think is probably what happens in America. But if it's to weed out corruption or bad malpractices, I can see the positives. So I'll be interested to see what the other guys say about it.
Keith, Harry?
Harry, you want to go first?
No, you go, Keith.
I'm sure Keith has plenty to say about
Yeah,
this.
I know. That's what I would.
So, very, very interesting question. About 3 months ago, I was in the US at for those of you in the audience who are interested, there's an extremely good conference which is run by an investigative journalist by the name of David March, and some of you may have heard of it, called Offshore Alert. An Offshore Alert, which normally runs in London, Miami, and in Kuala Lumpur. They invite a whole series of regulators, law enforcement specialists, journalists, investigators, forensic specialists. It's a sort of who's who of the fraud-related community at a very international level. And we were in the audience very appreciative of an amazing presentation by Revenue and Customs, who have actually set up an office in Miami and were advertising, and I'm not joking actually, were advertising this new service, which is something that actually I think Rishi Sunak had initiated, but is now fully operational. And we've since reached out to them, and it'd be interesting to work with them in relation to it. I say bring it on. And that's not in any way diminishing what Richard said about it. There'll be teething problems, no doubt. They are prepared. Revenue and Customs will pay from memory, so please don't quote me on this, but from memory, up to 30% of the tax that has been evaded by the miscreant who's failed to account for his tax, where the information that leads to the recovery of that comes from a whistleblower. They will pay that to the whistleblower. and they have launched a special unit in the States. There's many UK should be or absent taxpayers who should have accounted to, we need the money, let's face it, particularly with the challenges we face on a daily basis without being political. And they are hoping that there will be a huge return to the Exchequer consequent upon this. And it's very interesting to hear the Jonathan Fisher recommendation, a KC recommendation, because I think that will be the new world. And the US is far ahead of us in this area. So we're not all of us, for obvious reasons, appreciative of everything the US does, but they've shown the success. And there are many law firms, household names, who have practices acting for the whistleblowers, where their fee income derives from the return to the whistleblower paid by the US government from the discovery of fraud. So it's another business model in that sense. But if that actually...
Is that a plug, Keith?
No, it's not. I hope not. I didn't intend it to sound like one. If it didn't, I apologise for that. No, I just think that if you are serious about attacking fraud, and we've been far too, in my respectful view, we've been far too British and gentlemanly in thinking, it's all a bit sort of, it's too unpleasant. It lacks the British sang-froid courtesy that characterises, we like to think ourselves. I think if you're really serious at attacking fraud, particularly where there are inadequate resources, I've always thought if you're dealing with major international fraud and recovery, never use the law enforcement authorities, the SFO, the CPS, the police as a debt recovery mechanism. Use the civil courts, commercial court, chancery court, business and property courts now for the purpose of making proper recovery.
Harry, anything to add there?
Yeah,
For Richard on recovery.
just a few thoughts, which is, how much awareness is there of this, or will there be? It's a bit different. Like I don't recall seeing any ads. There may be ads. Like how is this going to pervade culture in the UK and maybe change behaviours? But maybe it will. So it seems like there's some work to do there. And then in terms of resource, and the US, looking at the US obviously actually spends a great deal on law enforcement, and I feel like we pale in comparison. So I do slight concerns about the resource, and it feels like maybe a great idea, but and setting up an office, 2-man office in Miami might make all the difference. But I do wonder how realistic it will be for significant gains. And yeah, look, there's that natural sort of maybe British reaction to these things. However, we do similar thing. We do reward schemes in lots of other sort of information and things like that. So it's not like it shouldn't be, it shouldn't be something that people be willing to do. But yeah, those are just my sort of reactions on it.
Harry, I have got on my desk, make everybody laugh as we come to an end, I have got a little red bus, a London Transport bus with HM Revenue Customs on it, which was one of the free gifts they were giving out as they launched this particular product. So it's my so maybe there's force. We'll
I hope they've rebranded them to the B network in Manchester.
Indeed. Well, we'll see. It was the proof of the pudding, I think.
Excellent. We have one final question just to wrap up. Just some very quick thoughts from each one of you, but just sort of looking ahead. If you had to bet on one regulatory or enforcement trend that will most shape corporate fraud response over the next, let's say, 1 or 2 years, what would that be? Richard?
Yeah, from me, I think it's just going to be the new offence. I think organisations are going to have to demonstrate not just that they've responded well to a fraud, which they're probably doing well already, but now it's going to be looking at the procedures, what were in place to prevent it from happening in the first instance. If they aren't there, then that's where they'll get called to account. So I think, yeah, boards now own the risk. They're going to be culpable for it. And it's now a case of just making sure from the top down. So it's all very, very similar to the anti-money laundering procedures, which I've bored people to death with for years. It's now looking at this culpability from the top down. And it will be interesting to see the very first enforcement, or a very large scale one, which will become public, and everyone will take a lot of learning from that, I can imagine.
Yeah, there's actually another question here from one of the attendees, and this one was for Keith, basically asking you, Keith, if you're looking forward to defending the first bank to be charged under the failure to prevent fraud legislation. Anyway, Harry, what is your take on looking ahead?
Yeah, well, I mean, it's maybe again, it's pretty obvious, but I mean, it seems like a lot of conversations have been dominated recently by AI, and I suspect that that's a similar thing. And not just conversations, general conversations from a business perspective. You know, how can we use AI to improve what we're doing, efficiencies and processes, etc. And so, therefore, this may be a thing that again asked questions by regulators or law enforcement, other authorities, to what extent we are using or have used AI to within our controls, within our assessments, within our detections, etc. So that seems to me like a classic thing in the next 12 to 18 months.
Excellent. Last but not least, Keith.
Yeah, well, in relation to that very direct question, absolutely, bring it on. I think, but let me. I'll just give you a little bit of because I gave some anecdotal historical experiences. In the Guinness scandal of the 1980s that led to the prosecutions, and I'm sure many of the audience will remember this. In the subsequent Court of Appeal proceedings, we were able to get access to cabinet minutes at the time, when at the time of Margaret Thatcher's government, cabinet minutes recorded one of the, I won't identify whom, cabinet ministers saying, we must get the handcuffs on quick. And the key point, the key takeaway is that if you're serious about this, you know, you've seen calls in the press for heads of water companies that are poisoning people with rivers, with sewage and the like, to be imprisoned. You've got to imprison people, however difficult that is in the current climate, and have long deterrent sentences, because that's the only way ultimately you'll change corporate behaviour. And although that may be very challenging, if you look at Tom Wolfe's Bonfire of the Vanities, which is apocryphal in terms of the 1980s in the boom years of that generation, actually, that's the way that you deal with crime, and you punish it, and punish it severely.
Yeah, no. It's interesting. I'm currently reading the book by Jesse Eisinger, The Chicken Shit Club. I don't know if you've heard of it. I mean, just basically about how it's getting harder and harder for prosecutors to actually, you know, put people in jail. So it's interesting. Well, that's the end of the webinar. I know we can spend another hour covering some of the questions that I had to leave out, and some of the other questions that we had from the audience. But in any case, thank you very much, Keith, Richard, and Harry. Thank you for participating.
Thank you. Thank you, audience.
It was a pleasure. Thanks for the audience for being here. Thanks for GLG to co-organizing this with us. I'm going to hand things over now to Ella, who's going to say goodbye. And until next time.
Yeah, thanks, guys. I think the audience will definitely agree. It's a very entertaining but also helpful conversation. So thank you all for your perspectives on those topics. If anyone from the audience is interested in reading the CDR Fraud, Asset Tracing and Recovery publication, we'll be sending you guys an e-version following the webinar. And yes, there were a couple of questions that you guys didn't get to answer, so we'll pass those questions over to the speakers. And if they have any incredibly interesting thoughts, I'm sure they'll get back to you. But thank you very much, guys, and see you in the next one.